his so-called colleagues in Congress have every incentive to make sure that he doesn't plead guilty so that he can stay in Congress through the duration of his term, because they need him there. And so they're going to do everything in their power to influence him to fight this case for their own benefit, not for his benefit. George, I'm not giving you legal advice, but if you do that, it's for them, not you, and it's going to go badly for you. So you better be ready for just how badly this is going to go when you lose acceptance of responsibility.
Yep.
And get all these other enhancements because you thought it was going to be a good idea to fight this to the death.
Over 1 million Americans face sentencing every year, and it will be the most important day of their lives. But we don't fully understand the system, how broken it is, and what we can do to make it better. I'm Doug Passon. I'm a 25-year criminal defense lawyer and a sentencing expert. My goal is to bring more awareness, more fairness, and more humanity to the sentencing process. So, are you ready? Then let's get set for sentencing.
Hey everybody, it's Doug Passon coming to you, my secondary Studio 3553 today. I'm in the playing the home version of the game today. It's Mother's Day Sunday, but we had to take a quick break out of our Mother's Day festivities with my good friend Mark Allenbaugh to talk about some interesting current events, as we like to do on this podcast when it relates to sentencing matters, and that is the fresh indictment of Congressman George Anthony DeVolder Santos. He has unfortunately, or fortunately, if I may quote the former president, been indicted in federal court on some pretty serious fraud charges. So here to break it down. What are the possible punishments? And, we're not giving actual legal advice here to anyone or Mr. Santos, but we may have our perspective on next steps that might be prudent for this gentleman as he tries to navigate the horrors of having the full weight of the federal government bearing down on you in the form of a multi-count fraud indictment. Good afternoon, Mark Allenbaugh. How you doing?
I'm doing well, Doug. How are you?
I'm swell. Good. So let's get right to it. I'm sure you have a PowerPoint.
Yes.
But we got a lot of different charges, and I want to know how might this shake out under the guidelines? What are the real numbers that he could be looking at?
Well, so the first thing to look at is the indictment here. Let me bring up the PowerPoint. So this is just the first page of the indictment. He was charged on May 9th, as we know, with several counts of wire fraud, theft of public of the public fisc, if you will, with respect to taking money for welfare that he didn't need or deserve or didn't qualify for, is probably the better way of putting it, and money laundering. He got hit with some money laundering counts. So this is just the front of the indictment. What I did here on this next slide, can you see this?
Okay. Wire fraud, yeah.
Right. So I just broke out the various counts here. So he has 5 counts of wire fraud, and the wire fraud pertains to what the government calls fraudulent solicitation of political contributions. So in other words, he defrauded all of those members of the public that he's solicited funds for to get him into Congress. So whenever you donate the $5, $10, or $100 to a congressperson, it's to help them get into office. That's why they're soliciting money from you. And what Mr. Santos was allegedly doing is he was taking this money, and it really wasn't for him to run for Congress, even though he ended up there. And that's, I think, might be a good defense for him. Like, I did end up in Congress, but he was using this money for personal gain, as set forth in the indictment. Anyway, he got charged with 5 counts of that. Each count carries a 20-year stat max, and so the total for those 5 counts is 100 years. He's looking at 100 years just on those wire fraud counts. And when I say he's looking at 100 years, that's the statutory maximum penalty he's not going to get anywhere close to 100 years under
Yeah.
the guidelines, and we'll get to that in a second.
Now,
And then there's
just can I break down? I
Sure.
just got a question because
Sure.
I'm not 100% sure of their theory, but you're saying the fraud element is that he's raising money saying it's for the campaign, but he's using it for personal expenses.
Correct.
Is there no fraud element for blatantly lying about his qualifications for office, his educational background, his work history? These are the things that presumably make you electable or convince a voter to vote for you, or to give you money to support your candidacy. He's flat out lied, and he's raised funds off that. Is that not any part of the theory of the case here?
That's not any part of the indictment.
Interesting.
Maybe that might come up during trial if he decides to go to trial, and it'll certainly come up at sentencing should he be convicted. But here, the way I read the indictment is the government's theory is that he basically used these political contributions for his own personal gain, paying off his credit card debt, buying really fancy suits and things of that nature. Which, by the way, I thought all politicians do that. But at any rate,
but I'm wondering why that's not part. I mean, I know it's probably another podcast, and maybe I need to ask a prosecutor, and maybe they need a victim to say, I would have never donated to his campaign had I known he never graduated from Baruch College or whatever. But I can't imagine it'd be that hard to find people like that. But anyway, I guess I'm just wondering, my bigger question is whether we could portend any future for the former president having now, fraud charges based on political fundraising, given that Donald Trump has raised hundreds of millions of dollars off the big lie. I just kind of wonder what does our crystal ball say that this?
Well, I think this certainly does not bode well for Trump, because this is arguably what he was doing, especially after January 6th. And a lot of his political, from what I understand, a lot of his political contributions that he received weren't used for his campaign, and are not being used for his campaign. It's rather for his legal bills.
Okay.
For his personal legal bills. And that doesn't bode well. And I think, frankly, if I was a prosecutor, and I'm not, it would be easier to prove that the misallocation of funds than trying to get people up on the stand that voted for Trump or Santos in this case, and say, well, if I had known he wasn't as good of a volleyball player as he said he was, then I wouldn't have voted for him.
If I had known his mother wasn't in 9/11, by the way, Happy Mother's Day. I'm really glad you weren't a victim of 9/11.
Right, exactly.
To George's mom, that's Mother's Day. If I'd have known that you didn't have best friends killed in the Pulse nightclubs, we could go on and on about this.
Right.
But okay, well, that's good to know. That's kind of interesting. I get, because there is a materiality element to fraud, so these lies in and of themselves may not be criminal unless they materially impact it. Okay. All right. So money laundering is a big one, and just so people know, money laundering is the darling of the prosecutor, like conspiracy is, and for the simple fact that the money laundering guidelines, correct me if I'm wrong, you're the guidelines guru, but those money laundering guidelines are higher and uglier oftentimes than the normal guidelines, right?
Right. But in this case, the normal fraud guidelines are worse for George. And I'll explain why when we get there. Yeah.
All right. Theft of public money, unemployment benefits. There's one count there, which I think is really swell, because aren't the Republicans the one, like, we don't want handouts, we don't want what do you call those, entitlements? But it is ironic that he's the Republican accused of stealing unemployment benefits. But okay, and it's a misdemeanor, you say,
and it's a misdemeanor count. So they just got to get that little dig in there, I guess.
Stat max of 1 year for a misdemeanor.
1 year, that's correct.
And there's only one count.
Yeah, one count.
Okay, then we got 2 counts of wire fraud,
which is the unemployment benefits also. And
so those are felonies, though, right?
Yep, those are felonies, 20-year felonies. And then
that kind of does tell you what a bullshit statute wire fraud is. So you've committed the crime, it's a misdemeanor, but because you used email or telephone or something that every human being uses every single day of their life, Now it's a felony because it's federal.
Now
That's
it's a federal felony. Yeah.
Fuck off with that. Go ahead.
Yep. And then the last one, which I find is the most interesting charge, is the false statements to Congress. And here, if I understand the indictment and the press release and some of the press reportings, that when I say the press release, I mean the DOJ's press release on this. It's not what the false statements was basically Santos boasting about how wealthy he was and how much money he had in various checking accounts and stuff like that. And he didn't have all that money. He had very little, as it turns out. So the falsity here is that he overstated his wealth to Congress. And here this kind of goes along with his boasting and all the other the lies, frankly, that he told about his background in order to get elected. So here, these last two statements, even though they're all financial related, they had to do with his financial disclosures. I think this is where the boasting kind of bites him in the ass. But what's interesting to me about these charges is that there's no loss with respect to the false statements. It's just that he lied about how rich he was, and that got him in trouble. He just couldn't help himself to tell the truth that he doesn't have a lot of money. It didn't hurt AOC. She didn't have a lot of money when she was elected to Congress. But for whatever reason, he felt like he had to portray himself as this multimillionaire, which of course raised a lot of questions.
Yeah. Okay.
And I think that may have been his Achilles heel. So at any rate, the point is, at the end of the day, he's looking at 211 years. That's the statutory maximum that the court could, if he's convicted on all counts.
Yeah, and then if all counts are stacked, or what we call consecutive, which, by the way, almost never happens in our system. So that's we're not saying that's anywhere near what he's
not going to get anywhere close to that.
And anybody who knows by now that there are two things we're looking at. One are the statutes, which we just did, and what are the statutorily prescribed punishments and maximums. So that's 211 years. But of course, we have to go to the sentencing guidelines, these broken, flawed matrix of punishment that's going to give us what the advice to the judge is about what a sentence should be if he's convicted of all of these. So what do the guidelines say, Mark Allenbaugh?
Okay.
What's behind door number 2?
Here's behind door number 2. Now, there's two assumptions here. One, you hit on this a little bit earlier. Usually when somebody is charged both with money laundering and a fraud, the money laundering guidelines can be worse. But because of the nature of it, when I say worse, I mean they result in a higher offense level. So you end up using the money laundering guidelines. But this is one of the cases, not really rare, but I guess unusual, where somebody has been charged both with money laundering and fraud, and the fraud guidelines, or 2B1.1, end up resulting in a higher sentence. And you'll see why here in a minute, and has to do with the various SOCs, specific offense characteristics. There's an additional specific offense characteristic available here, or actually a couple that are available here that are not available under money laundering, which results in a higher offense level under 2B1.1. So you'll see, as you can see here, the total is 26, and I'll go through these really quick. But if you calculate under 2S1.1, which is the money laundering guideline, you only get to a 24. So here you would use a 26. And by the way, this is a little bit inside baseball, but all these different counts, they group together because they all have to do with pretty much the same offense conduct. The guidelines treat all these different charges as if it's one big offense. And so that's why we don't have guidelines.
And this tells you how convoluted the guidelines or how dense I am. But I've been dealing with the federal sentencing guidelines for 20 years, and I still don't understand grouping.
Yeah, it is very convoluted and very technical, and But at any rate, okay. So we start off here under the fraud guidelines. We start off with an offense level 7. Because if you're charged even with one count that carries a 20-year maximum or more, you start out with a 7. And now I'm assuming here what's kind of hard to tell is what the loss amount is. And I have a little bit of a typo in here, but I'm assuming that the loss is more than 550,000, but less than $1.5 million. And that may be conservative here. And I'm just basing that on just some of the press reports that I've read in terms of how much money had been contributed to his, not only contributed to his campaign, but the amount of money that he was really laundering. In other words, those laundering counts, there's the 3 laundering counts. And what he did, how he laundered the money is people would contribute to his political campaign. That would go into the campaign's account, and then he would move money out of the campaign's account into his personal account. That movement was the money laundering, because now it went from a political contribution. He basically stole from his campaign to fund his own lifestyle, and that's where the money laundering comes in. So,
which is another sort of like, okay, it's just moving funds from here to there that are you can easily trace, but that's money laundering. And by the way, you touched on the thing that we touch on every single time that we deal with a fraud calculation under these guidelines is what's the loss. And it's interesting that it's almost never going to be alleged in the indictment, so it's never a simple matter, and that is probably going to be the most litigated aspect of this case. No, I moved it to this account, but I actually spent it on this, which is legitimate expenditures and blah blah blah. And lawyers are going to spend a lot of time and a lot of resources trying to whittle that number down. Because look at the guideline bump. It goes from a level 7 to a level 21 just because of the loss. So that's a lot.
And this is, I think, an inherent problem with the guidelines and how they're structured, and what they've done to criminal justice system over the last 30, 40 years is these sentencing enhancements, such as loss amount, are not charged and therefore do not need to be proved to a jury beyond a reasonable doubt, under the rules of evidence, by the way. So no hearsay can support this loss amount, etc. So what happens in reality is that this loss amount is only determined at sentencing by a single judge. There's no jury. It's by a single judge using a preponderance of the evidence standard, and no rules of evidence apply. So the judge can rely on hearsay or just an Excel spreadsheet submitted by an FBI agent. That's very often what the proof of loss is at sentencing. It's just, judge, look at this nice Excel spreadsheet that this FBI agent made, and there's your proof. That's the proof of loss, which is arguably the most important factor in a fraud case, is how much it losses, because that ultimately determines the sentence. But there's no protection for that. It's just basically, that's about as sophisticated of a methodology that's employed in determining the loss amount. Ironically,
which is, if it wouldn't, it's fundamentally unfair on its face, the way you describe it. But when you look at the tripling of the sentencing, guideline range, it's the unfairness is hard. It's so unfair, it's hard to wrap your head around.
Correct. And as we've discussed in prior podcasts, the Supreme Court is going to consider whether acquitted conduct withstands constitutional scrutiny. But if it doesn't withstand constitutional scrutiny, then also stuff like this, like uncharged conduct, loss, which is uncharged conduct, also cannot withstand constitutional scrutiny. And don't believe me, DOJ has said this in its own briefs, Supreme Court briefs in opposition, as well as Justice Gorsuch when he was on the appellate court for the 10th Circuit, and Justice Kavanaugh when he was on the appellate court for the DC Circuit, and Justice Scalia when he was still around, had said the same thing, that this is very problematic for the reasons what we just described, because it's and I think it was Scalia that famously said that the guidelines are basically the tail that wags the dog.
And this is a perfect example of it here. All right. So tell me about, so there's 2-level bump for 10 or more victims. That makes sense. But this next one is one I don't think I've ever seen before. There's an
I haven't either.
What is this enhancement?
It's been in there forever. It's basically you're misrepresenting the defendant has misrepresented that he is collecting, or she, but usually he, is collecting money on behalf of a political organization. Now, you would say, well, Mark, this is the case par excellence, where he really was, where Santos was collecting money for a political organization. Yes, but if I'm a creative prosecutor, and if I am also a very aggressive probation officer in calculating the guideline range, I think it's an easy argument to make that this misrepresentation that he was collecting money on behalf of a political organization would apply, because he really wasn't collecting money on behalf of his campaign, his political organization. Rather, it was just for him to enrich himself.
Yeah.
So I have not seen this before, and I haven't researched how often it's been applied, but just anecdotally, I can tell you it's not applied very often. But I see it in a case. I see it in a case like this.
Okay.
Even though it involves a political organization, but the fact that he stole from his political organization, I think, is what will. Why it triggers this.
All right, so that'll be interesting to see. And these are always, what we're doing here is what we do for our own clients, which is worst case scenario. Like, we're not saying for sure. You never know for sure unless you can negotiate some of these away in a plea agreement. But otherwise, you just have to say, look, there's this thing out there that could come back to bite you at sentencing. So you've got another one. Sophisticated means another 2-level increase. Is this really that sophisticated? It's just moving money from one account to his private.
Well, according to the application notes to the sentencing guidelines, pretty much that's all that's needed. If you're just moving money around from one account to another, that can constitute sophisticated means. Now, arguably, sophisticated means should only apply for offense conduct. Not that the offense conduct is inherently sophisticated, rather that the offense conduct is very sophisticated relative to other offense conduct of that same type. In other words, was this fraud committed in an unusually sophisticated manner, as opposed to any other fraud, as opposed to fraud just being sophisticated in general. And here, I think there is an argument that there was some sophisticated means that was used. And this may come back to the volleyball misstatements, and that he embellished and created this whole background story about who he was in order to get people to contribute to him. And that involved a lot of fraud and deceit, and took a lot of work. And there's some sophistication involved with that amount of hubris. And from what I understand too, from the indictment, is he did a little bit of the same thing in his prior run for Congress when he lost. He ran back in 2020 and lost back then, but he was trying some of the same tactics and overstating his resume and embellishing, if not outright lying, like he did this time. So I think there's an argument here that sophisticated means certainly would apply, and plus with the moving the money around in various accounts.
Yeah. Okay. All right. So then we have role in the offense. So the guidelines look at whether you're a leader or an organizer, whether you have a minor or mitigated role, and they can go up or down accordingly. You have it adjusted 4 levels for leadership role. How come?
Role. Well, because if he had 5 or more participants, or if this was otherwise extraordinarily, or if it was otherwise complex, that's the terminology, is otherwise really complex, then this would apply. And it's generally when there's 5 or more other participants involved. And I would probably come out that there were many participants that had to help him in his campaign. I mean, he did, as noted in the indictment, he did hire a campaign consultant to help him solicit money on his behalf, and he was directing that consultant on what to do. And I'm sure that consultant had other people that consultant was directing. So it seems to be here pretty clear that the leadership role could apply. I think there's a good argument that it would apply here.
Although we have to hearken back to our friend, who we don't know personally in any way or form and have never represented, Elizabeth Holmes, who
Yes.
was the head of Theranos and somehow avoided any leadership role enhancement.
Yes.
So
Yes.
one
Yes.
never
That's
knows
true.
for sure.
One never knows.
But
Go ahead.
because you would think by definition she was a leader of the whole organization. And then in this case, leadership, a congressperson is by definition a leader.
Yeah.
But who knows? We'll see. Again, worst case scenario, I would hope that a good lawyer could deal with that, or at least knock it down a couple levels. And then you so generously, this is really interesting. We got to talk about this, but you factored in acceptance of responsibility, which
Correct.
is if the guidelines shake out to be 16 levels or higher, you're entitled to 3 levels off if you accept, and then you've built in another 2. So
which is actually that other 2 is incorrect, by the way. I just realized that this is but it's worth noting.
Why is it incorrect? Okay. And
okay,
first of all, where did it come from? And then we'll say why it doesn't apply. And we have a whole other podcast on this, just like we do on acquitted conduct. So I'll put both of those links in the show notes at www.setforsentencing.com/Santos. If you want to see these PowerPoints and see these links to the other more in-depth discussions, because we're kind of bolting through this fast. But tell me about the 0-point offender.
Okay, so the 0-point offender, it was a new downward adjustment created by the commission. It's right now pending before Congress, and almost to a certainty, it will become law, if you will, or will go into effect on November 1 of 2023. What this downward adjustment, it's a new downward adjustment that's in 4C 1.1 in the criminal history section of the guidelines. And it says that if you, the defendant, have 0 criminal history points, you could have criminal history, but as long as none of your criminal history counts where you get any points, and you meet a variety of other criteria, you get 2 levels off of your offense level. One of those criteria, though, is that you cannot have a leadership role enhancement or a role enhancement, whether it's 2, 3, or 4 levels. So if Mr. Santos gets this leadership role, he definitely does not qualify for the 0-point offender adjustment. But if he's like Elizabeth Holmes, as you point out, and he doesn't get a leadership role or any type of role, whether it's 2, 3, or 4, then he is eligible for the 0-point offender enhancement. And just one little note on that. While it does not appear that he has any criminal history here in the United States, it does appear that he does have criminal history in Brazil. But the guidelines expressly state that any foreign convictions do not count for purposes of calculating the guidelines. So he still would be a 0-point offender, even with his conviction. I think it was for embezzlement or something like that. In Brazil.
Okay. Well, guess what then? If I'm a lawyer in this case, I want to negotiate. I want to see if I can get a stipulation, which is sometimes hard to do depending on the district, that there is no leadership role, because that's going to be a major help in the guideline calculations. That's assuming he pleads guilty, and of course everyone is innocent. We know that the presumption of innocent attaches. But I want to go back and do this guideline calculation again, because we know that he pled not guilty, which every single defendant almost pleads not guilty. So there's nothing to be discerned from that. But then we also know that he did the press conference on the courthouse steps saying, I'm 100% innocent. This is a witch hunt. He used the word witch hunt. I'm going to prove my innocence, blah, blah, bleep. So the idea, and by the way, Congress, his so-called colleagues in Congress have every incentive to make sure that he doesn't plead guilty so that he can stay in Congress through the duration of his term, because they need him there. And so they're going to do everything in their power to influence him to fight this case for their own benefit, not for his benefit. George, I'm not giving you legal advice, but if you do that, it's for them, not you, and it's going to go badly for you. So you better be ready for just how badly this is going to go when you lose acceptance of responsibility. And get all these other enhancements because you thought it was going to be a good idea to fight this to the death. But do the calculation without that.
Without acceptance?
Yeah, without acceptance. Can you still get the -2 even if you go to trial?
Yes.
Okay.
Yeah, you could still get the -2, the 0-point offender adjustment. You can still get if you go to trial.
Okay.
That's not a problem. You don't have to plead guilty in order to get that. You just can't have a leadership role. You can't have a leadership role. You can't have committed a terrorism offense or received the terrorism enhancement.
Okay.
And there's other criteria that just don't apply
So
here.
we just have to add 3 to possible level 26. So what's a level 29 criminal history category 1?
Well, so before we calculate that, are we going to keep, if we keep in the leadership role, then he can't get the 0-point offender. So we're going to keep the leadership in or take that out?
We probably should, because here's the thing, like when you go to trial, there's the trial penalty. It sucks. But you're less likely to get the benefit of the doubt at sentencing on these enhancements once you've gone through a trial. You're going to have to fight like the devil for every single level, and so you're giving up the opportunity to stipulate it away as part of plea negotiations, whatever. So let's keep the leadership role, which means we got to lose 5 levels now. So what are we at, 31?
We're at a 31. So
see how good my math is?
Your math is excellent. So let's go ask Jason what a 31 looks like.
Jason.
So
first let's ask the guidelines, and then let's ask Jason. What does this stupid chart say?
Well, the stupid chart says, and you ignore the highlighted stuff. This was for if he was at a 20 final offense level of 27, actually.
Stupid chart says 108 to 135. So
108 to
like
135.
9 to 11 years, basically.
Yeah.
Okay.
So now let's actually run it, and I'm going to just.
Well, we could do Jason for the plea calculations too, as long as you've got them there.
Yeah. Can you see Jason right now?
And by the way, for those of you who don't know what we're talking about, Jason is not the Friday the 13th masked serial killer. Jason is the judicial sentencing information database, where they give, because you have the guideline table, but nobody follows the guidelines. So they've done very careful data collection to tell us what are the really kind of median sentences that people get under these statutes. So you got to look to Jason. So now there's 3 places you got to look. You got to look to the statutes, you got to look to the guidelines, and now you got to look to Jason. That in and of itself should tell you how convoluted and crazy federal sentencing is. But guess what, folks? We did a whole podcast on it, and most likely that's last week's episode. So again, go to the show notes for the Jason podcast.
Okay, so if we're going to look at trial, worst case, at least the way I calculate it, worst case scenario for trial, he would be at an offense level 31, and I'm assuming only criminal history 1. So we go down here. So first thing we do, as we did in the Jason podcast, is you select your guideline 2B1.1, make sure no mandatory minimums apply, check the box that everybody forgets here in the lower left, and then you go over to 31, criminal history 1 right here, and you just click. And then magic is going to happen in the upper right here. We could see Jason is working, and out pops that it found 96 defendants that fit that criteria, that over the last 5 fiscal years, sentenced under 2B1.1, final offense level 31, criminal history 1, who did not receive a 5K 1.1 motion for substantial assistance. In other words, they didn't cooperate, they didn't plead guilty, and they didn't cooperate, because you can't get cooperation unless you plead guilty. So out of those 96 defendants, the average sentence was 83 months. So he's basically about 7 years, and the median was 86 months. And for those who forget what median means, median is just you take all 96 of those sentences and you line them up lowest to highest, and you pick the one right in the middle. And so what that means is that half of the 96 received more than 86 months, and the other half received 86 months or less. And so he's looking at around 7 years if a judge was to give him a roughly typical sentence.
Okay.
I'd say probably more along the lines of like 6 to 8 years. If I was to go in, what I do is I dig into the data to get a better understanding of the distribution of the sentences. These naked numbers don't give you the distribution.
So can we go back and just do it, assuming he gets acceptance and the 2 levels? So back to the level 26.
Okay, well, so
It
if
could
he
be a
got the
big
2 levels
difference, right?
down, yeah, he could not, it's gonna make a huge difference. And he cannot get the leadership role either.
Yeah.
So,
So we're
without
talking
the,
about 4, 5, 6, 7, 8, 9. We're talking about 9 levels off.
yeah, so he would
Okay.
be at a 22.
Okay.
Okay, so that's 41 to 51 months is the range.
Under
So
the
now,
guidelines table, yeah.
Yeah.
And now what is the real
and so
world
the real
sentencing
world is
range?
there's a lot of those guys, 493. The average sentence was only 32 months, and the median was 35 months. So he's going from 6 to 8 years to around 3, less
Mhm.
than 3, less than
And
3
that's
years.
not even counting good time credits for step back credits
That's
and those
correct.
types of things. So we're
Yeah.
talking about a couple of years
Yeah,
max.
this is actual sentence imposed. This does not take into account the 15% for good conduct time that virtually everybody gets. And then the
Yeah.
first step back credits that can take up to 10 to 15 days off of your
Mhm.
sentence, roughly, for every 30 days that
Mhm.
of programming that you successfully complete.
That's very interesting. And I will say this, that
So
you
he's looking
know,
at doubling. I'm sorry to interrupt
yeah,
you, Doug, but when you look at this, and if you're counsel for him, what you can say is, statistically speaking, and by the way, there's a lot of problems with the statistics and data with Jason, but setting
yeah.
those aside,
Well, we got a
that
whole
aside,
podcast on
yes,
it.
we have a whole podcast on that. But setting all that aside, they're good enough where you can counsel could tell Santos, look, if you go to trial, you're going to have a significant trial penalty. You're going to be looking at roughly double what you would get if you plead guilty. Actually, more than double than what you would get if you just pled out. That's
Yes.
significant. That's a
Now,
huge disincentive for going to trial.
yeah. And again, presumption of innocence, but we got a couple problems here. And, we've talked about really 3 things we're looking to give some idea of what we can. It's never any certainty. We're looking for some idea of sentencing. So we've talked about statute, we talked about the guideline table, and we talked about Jason. But there's another huge missing piece here, which is, what is the story?
Yeah.
Because the story, the emotion of it, how we feel about George Santos is going to animate the sentencing outcome. I know this because it happens in every single case we ever had. All these guidelines are advisory. So how, Judge, are you going to feel about this man that is before you, whose fate you're trying to decide? And so what is narrative? Narrative, says my story guru, Dr. Randy Olson, is a series of events that occur in search of a solution to a problem. All we do in telling the true story of our clients at sentencing is, first, what is the big problem? Identify that problem and build a narrative around it. And George Santos, for a person who's now charged with fraud, which is fundamentally about being a dishonest person, is got a real big problem. And that is, he's been caught red-handed, dead to rights, telling lie after lie after lie about his life. And some of that's incorporated in this indictment, but a lot of it isn't. And so if I'm an attorney for a person who is literally, I don't think there's any better way to describe it than a pathological liar, I want to ask why. What the fuck is going on with a person that compels them to do it? Because the government has their story. They're just fundamentally a bad, deceptive, greedy, like narcissistic, fraud, like everything we hate about fraudsters. And I just look at this dude and I just feel like there's a lot more to that picture.
Yes.
And we have to figure out what that story is.
Yeah.
And then the other big problem that we have is, at this moment in time, he is unrepentant.
Yeah.
He's doubled down on the lies. He is using the witch hunt language, and that's going to be fine for a press conference. It's going to do nothing for him when he steps inside that courtroom. In fact, it's going to kill him. It's going to hurt him bad.
Yeah.
So no matter what these so-called friends of his in Congress are telling him, and they're probably going to finance defense and say, fight it, fight it, fight it, fight it, fight it, you need to know that that's not going to be good for him. It may be good for his friends in Congress, but at the end of the day, he's going to pay dearly for that decision. And so the time to start expressing some humility and contrition was yesterday.
Yeah. And, and one thing I would add, though, too, Doug, and not nearly as eloquent as you're putting it, but going back to kind of inside baseball, is he's looking at a total of 13 counts. And I'm on this acquitted conduct mantra for some reason. And one thing that he also has to consider, and his counsel has to consider, that even if he's acquitted of most of those counts, he only has to be convicted of one.
Mm-hmm.
And all those other counts still come back in to bite him in the ass at sentencing. So it's not that he has to win most of them or win some of the big charges. He has to win on all of them in order to walk out of there. I mean, if he was to get convicted of just one, I would want it to be the misdemeanor, and then he'd be capped out at a year. But that would be it. If he's convicted of just any of those 20-year frauds, he's, or even the 5-year, he's everything else comes back in. Acquittals don't save him. It's acquittals across the board.
Yeah. And again, it's about how they feel after getting convicted of. If you go to plead guilty on one count or a couple counts, they could still roll in this acquitted conduct. But again, there's so much more leeway to do it, but it's about how is the decision maker going to feel about what you did, why you did it, and more importantly, what you're going to do about it.
Right.
And if they feel like you're just lying through your teeth and you're holding fast to the lies, and you're in big trouble. I mean, you're in very, very big. And I hope he understands how much trouble he's in right now. And I hope he makes some good choices, because fundamentally, I mean, he's not Charles Manson. I think he's troubled, and I think he's put himself into a box. He's in a tough spot, and he's going to have too many voices talking too much shit in whispering in his ear. And I feel bad. I legitimately feel bad for the guy.
Right.
I know that makes me a bleeding heart, and but I do. And I want you to talk about alternatives to incarceration, because when we were planning this podcast, and you thought that this case would be a good subject for this.
And thank you for reminding me of that. That's this was one of the big areas that the commission actually was looking at in this round of in this amendment cycle. The first amendment cycle it's had in 4 years was continuing its development and research into alternatives to imprisonment. And Doug, as you know, and we've talked about this in the past, prior to the guidelines, the default sanction for just about everybody was probation. Most people did not, when I say most, it was around 60%. Most federal defendants, once they were convicted, did not go to prison. They were on probation. They were given, if you will, a second chance. And probation, by the way, isn't a slap on the wrist. It does greatly constrict your freedom of movement, and you have to do a bunch of stuff. And you still have that scarlet letter of a felony over you, which really reduces what you can do with the rest of your life and where you can work and all this stuff. So it's not necessarily a slap on the wrist. But at any rate, there's more than just probation. There's terms of probation and what can be done. And it's I think what Mr. Santos, his very unique offense conduct screams for is not just an alternative to, I mean, we can throw him in prison like we throw everybody else and it does very little good. Or if I'm the judge, I could come up with a very interesting alternative to imprisonment where I can have some creative terms of probation, where we can have him doing certain types of community service and not just picking up trash per se, but giving speeches, speaking to young adults about what drove him into this. Have him speak at conferences and whatnot with political action committees and the things to watch out for, and how he got caught up in this. There's so many things that a judge could be very creative with and give a creative sanction that not only would punish George, but also provide some good out of this other than us just throwing him into a human warehouse like we throw everybody else. And it ultimately does society no good there.
Yes.
And so I think that's, that's what this, what this case screams out for is a bold judge, if it comes to sentencing, is a bold judge willing to consider not just alternatives to imprisonment, but creative sanctions that can be meaningful and to help not just George, but society and others. And this serves as one of the points of sanctioning is to deter others from engaging in criminal conduct. And what better way to deter future lobbyists and those that are interested in getting into politics than somebody who went down the bad road? And these are the red flags to watch out for. This is when I should have gone right and I went left. And these are the things you need to watch out for. That, I think, is much more powerful than just sitting in a prison somewhere.
I agree. I think we send far too many people to prison. Most of the people in federal prison are nonviolent offenders. There's a real problem with that. But a couple points. One is, again, if he doesn't fall on his sword and fully accept responsibility, I don't think there's a judge in the land that's going to be thinking about anything besides a prison cell for George Santos. And that's largely going to be a problem of his own making. And two, don't let us offer a practice pointer, which is, as a lawyer, don't just hope the judge can consider that. You go out and you work with your client and you develop these programs and you find ways for your client to start doing these things, and don't even wait till sentencing, by the way. Just go out there and show. Preferably you're doing this stuff before you ever get indicted, but that ship long sailed for him. But go out there and show you got time. This case could go on. You got time. You could be the guy that says, because listen, he's going to be infamous for one thing or the other, either being the lying lunatic who went to prison for a long time, or the guy who got off the merry-go-round and said, this is nuts and I'm sorry, and I'm going to figure out a way to make this right, not just for the things that I did and my own choices, but to try to make the system or the political process or the world a better place, because I care, because it means something to me, because I'm fundamentally a good human being and that my character is good. I'm not the guy that they say I am. And this is how you don't just say that stuff. You have to walk the walk to make it so. So I don't expect we're going to see that anytime soon from Mr. DeVolder Santos, but I hope we do, man. I really hope we do.
Yeah, so do I.
Yeah. So anyway, well, I know you got some Mother's Day stuff to do, and so do I. So thanks for taking some time on Sunday to talk about George Santos. Again, folks, check out the show notes. You've got good charts and links to a few other episodes that will put the meat on the bones of things we're talking about here today. Mark Allenbaugh, as always, sentencingstats.com. Check out what he does. It's very, very cool. We will be talking together soon. So thanks again.
Very good. Okay, thank you, Dad.
That's it for today, but before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works, I am so glad you're here, and I hope you keep listening. If you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassonlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign off on a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.